Good morning. Good morning, everyone. So wonderful to have you all here. I'm Päivi Kannisto. I'm a chief of UN Women's Peace and Security Section, and so proud of my colleagues' team's work here on this issue as well. So I would like to warmly welcome you to UN Women on this event on access to justice for reproductive violence. And it's a real privilege to join all of you. And also I want to thank warmly our co-sponsors, Australia, Slovenia, and the United Kingdom, whose leadership and commitment to gender equality and international justice make conversations like this possible, but they make it also possible to advance this work, advance justice. I would also like to extend our sincere appreciation to our partners and co-organizers, the Global Justice Center, the Center for Reproductive Rights, the Global Survivors Fund, Musicians for Human Rights, and the Women in International Law interest group of American Society of International Law for their remarkable work to bring critical evidence and legal analysis to global attention. Today, we gather to shine light on a form of gender-based violence that has too often remained at the margins of international accountability efforts, reproductive violence. As UN Women's 2024 joint report with the Global Justice Center underscores, reproductive violence comprises a range of acts that interfere with or violate reproductive autonomy, whether through forced pregnancy, forced abortion, denial of reproductive health care, targeted attacks on reproductive capacity, or punitive measures designed to control or police reproduction. Crucially, the report highlights that these violations are not incidental. They are frequently used deliberately, sometimes systematically, to exercise control, inflict punishment, or target individuals because of their actual or perceived reproductive capacity. One of our report's most important contributions is its insistence that reproductive violence be recognized as distinct, not merely an extension of sexual violence. It shows how the consequences of reproductive violence ripple across health, autonomy, family life, and participation in society. These insights are vital as the international community moves towards strengthening legal frameworks, including efforts to codify reproductive violence explicitly within the proposed Crimes Against Humanity Treaty. Documentation led by the Global Justice Center, Musicians for Human Rights, and others has already begun to reshape how investigators, courts, and policymakers understand these harms. Yet, the lack of systematic documentation remains one of the greatest barriers to justice for survivors. As we meet under the CSW70 priority theme of ensuring and strengthening access to justice for all women and girls, it is clear that justice for reproductive violence is inseparable from this broader agenda. The Secretary General's report for CSW70 stresses that access to justice is a fundamental prerequisite for the realization of all other rights, and that women continue to face discriminatory laws and structural barriers that impede their ability to seek redress. Advancing justice for reproductive violence therefore directly contributes to building inclusive and equitable legal systems. Systems capable of recognizing these harms, addressing impunity, and ensuring that all women and girls can fully claim their rights. That is why today's discussion is so important. The expertise represented here, amazing expertise, shows us both the scale of a challenge and the pathways forward. By centering survivors, strengthening legal recognition, and improving accountability mechanisms, we can help ensure that reproductive violence is neither overlooked nor excused. Again, welcome to UN Women and to CSW70. I look forward to today's discussion and to collective work ahead. And you are all doing critical work, and your support is critical for making a difference here. so that actually one day people affected by conflicts will have justice. Thank you so much.
Thanks so much, Päivi. Good morning, everyone. I'm Emily Kenny. I'm UN Women's Policy Specialist on Rule of Law and Transitional Justice. And it is my pleasure and honor to be moderating this morning's discussion about access to justice for reproductive violence. This is a topic that is really close to my heart at UN Women, and Päivi spoke about the report that we published, is it 2 years ago, Tess, now? 1.5 years ago with the Global Justice Center, and really seeing this topic gain traction in international spaces, and the interest in thinking about and working on and pursuing accountability for reproductive violence has been really amazing to watch. And I think it's really thanks to the work of activists and civil society partners like the amazing group before you on this panel today that we see this topic moving forward. So first, let me introduce you to our panelists for today. I'm going to move from my right to left. We have YY New, who is the founder and executive director of the Women's Peace Network. YY was a political prisoner for 7 years in insane prison in Myanmar and has since emerged as a leading advocate for justice in Myanmar, including for her community, the Rohingya. Payal Shah is the Director of Research, Legal and Advocacy of Physicians for Human Rights. She is a human rights lawyer with more than 15 years of experience in capacity building, coalition development, strategic litigation, fact-finding, and human rights advocacy. Maria Cecilia Ibanez is a senior advocacy advisor at the Center for Reproductive Rights. She was previously a senior attorney at Women's Link Worldwide and has extensive experience in strategic litigation and advocacy. Tess Graham is a legal advisor at the Global Justice Center. Prior to joining GJC, she was a postgraduate fellow at Just Security and a human rights technical advisor to ALEF, which is Act for Human Rights in Beirut. And joining us online, hi, Richard, is Richard Bennett. Richard is the Special Rapporteur on the situation of human rights in Afghanistan. He was appointed to that role in 2022. Richard previously served in Afghanistan on several occasions in different capacities, including as the chief of the Human Rights Service with the United Nations Assistance Mission in Afghanistan. And he previously served with the UN as representative for the High Commissioner for Human Rights and head of the human rights components of peacekeeping operations in Sierra Leone, Timor-Leste, and South Sudan, as well as twice in Afghanistan. So you can see that we have an incredible panel before us. So I, without further ado, will be asking questions to our panelists, and then hopefully we'll have time for a Q&A and conversation. I will do my best to keep you to around 5 to 7 minutes, please, so that we hopefully will have time for conversation with all of you at the end. So I think I'm going to be working in roughly the same order as your introductions, and starting with you, YY, if that's okay? Yes. Yeah, great. So YY, what role has reproductive violence played in Myanmar, including during the clearance operations and before? What impact has this had on the Rohingya society and individuals? And how has this been reflected in the case that is ongoing at the International Court of Justice so far? For you.
Thank you very much. It's an honor to be here. And that's a great question. Let me pull up my notes. Happy International Women's Day for yesterday. And I thank the event's partners and organizer for organizing this critical event. And for those who may not know you, again, I'm also the founder and executive director of Women's Peace Network, a human rights and democracy advocate, a former teen political prisoner for 7 years. And I'm, as I say teen because I was in prison because of my father's political leadership in Burma during the previous military dictatorship. So I'm also a daughter of a feminist political leader among the Rohingya community. And for Rohingya, the topic of reproductive rights has long been intertwined with the Burmese military systematic oppressions and prosecutions of the group. For decades, ever since I was young, let's say, since 90s, the military has introduced these discriminatory policies against the Rohingya women and targeted Rohingya women for their reproductive rights. It issues two-child policies, directives, local laws and directives, and they monitor Rohingya population closely to implement these policies. So Rohingya women were limited, restricted to give birth to only two children, and their marriage were monitored and restricted. So basically, Rohingya women were had to take permission to marry and to even, I guess, give birth. Without their, once you give birth to the children, and you need to register if you have accidentally give birth to the third child, and that child become blacklist on the list of, they call blacklist. So basically, that children, there was a generations of young Rohingya children who were not on the list of the government registry. So they were on the list of what they call blacklist, and that means that not only that these women were denied of reproductive care or health or rights, but also their childs were unable to receive any social services. And eventually they had to send these children to the third countries to survive as they grow up, because they were not able to access to healthcare or education or any of these things, because they are not listed anywhere, right? So, and then they have to hide the children when the military perform routine check every 6 months to their houses and villages. And that was not only the violations of reproductive rights, but also the harm that was caused against these women mentally. And the militaries, these kind of dehumanizations of women and the Rohingya continue for generation, reaching its peaks in 2016 and 2017. During the military's clearance operations, the Burmese militaries targeted Rohingya women for their reproductive age. Younger Rohingya women were raped, gang raped, and while they were doing so, they used words like, "We will destroy you," as they rape or gang rape the Rohingya women. And we have heard recently in ICJ hearing, it was fantastic, I think, hearing. I don't know if you had a chance to look at the hearing, the arguments that submitted by the team Gambia, the Gambia legal team was fantastic. They lay out these detailed violations of reproductive rights against the Rohingya women, specifically during the 2016 and 17 clearance operations, but at the same time laid out these historical violations of the reproductive rights of the Rohingya women. And now repercussions of this military violence can be seen today in the camps, in the refugee camps, as victims and survivors continue to face severe damages to their reproductive organs, as well as endless psychological trauma and suffering. Many women survivors also face stigma from their communities. Abortions was and continue to be criminalized in Myanmar, forcing pregnant people to rely on unregulated surgeries and pills, flee to neighboring countries, or give birth to their rapist child. On top of that, there is no healthcare accessible in Rakhine State at all. There's no, the healthcare system is effectively destroyed, and it's also true to the entire country. In other than bigger town cities, the healthcare system in Burma is effectively destroyed. Now, with the violence across the country, across the ethnic territories, the women are targeted for many forms of sexual violence. Similar tactics has been used against the other ethnic communities, women from the ethnic communities for decades, and they continue to do so. Now, in those areas as well, there's very, very limited access to reproductive health. And so I think that is something which is a major issue itself for Burma, which is experiencing decades of violence, atrocities, and conflict. And now I'd like to go back to Rakhine State a little bit, if I have a minute or so. In Rakhine State, now we have a new actor control the territory, which is the Arakan Army, an ethno-nationalist armed group. It's repeating history as it sexually violates Rohingya women and girls while destroying their homes and villages. Like the military, the AA is refusing to recognize Rohingyas' identity and leading group to the expulsions. Once again, we are seeing dehumanizations and destructions of the group through the use of reproductive violence, including rape, gang rape, and other forms of sexual violence. And so, therefore, as I've said time and time again at the Security Council, bold and concerted international actions for justice and accountability necessary to address the Burma case specifically. We also need to address specific measures to address the reproductive rights as it is the discussions of today. Often this issue is downplayed or overseen, and which is unfortunate. As we all know, in every conflict, women and children bear the bones, right? So I think in that sense, the reproductive harms itself is a serious violation of the human rights, and I think we should not allow to overlook these serious violations, because it's, again, as I described, it's carried among the victims and survivors for decades and for generations. So I hope that these discussions will invoke these further actions, and we can explore our recommendations together. Thank you.
Thanks so much, Wai. I think you've really done a great job of highlighting through the example that you shared that reproductive violence is not just incidental to a conflict, it's really systematic, and that's exactly the word that I wrote down. It's really at the heart of the strategy that's used in your own context, and we'll hear across contexts. And I think that really speaks to the importance of identifying reproductive violence as a specific form of harm and a crime, and pursuing accountability. So thank you for your call to action at the end as well. So now we will turn to Payal from Physicians for Human Rights. Payal, what forms of reproductive violence have you seen in Gaza? I know that PHR has very recently published a very compelling report on reproductive violence in Gaza, so it would be great if you could share a bit about that report. How can attacks on healthcare impact reproductive autonomy, and how do you see attacks on healthcare and on reproductive autonomy rising to the level of reproductive violence?
Thanks so much, Emily. Thank you to UN Women for hosting us today, and special thanks to the missions of the UK, Slovenia, and Australia for the co-sponsorship, along with Global Justice Center, Global Survivors Fund, and the Women's International Law Group, interest group of ASIL. In January, as you said, Emily, my organization, PHR, along with the University of Chicago Global Human Rights Clinic, published a report entitled Destroying Hope for the Future, Reproductive Violence in Gaza, which really aimed to understand the gendered impacts of attacks on health and assess whether the harm to reproductive health that we had been hearing about was in fact linked to a pattern of attacks on health, and also kind of unpacking and teasing through that question of when is the harm collateral damage versus when is it something that a state needs to be held accountable for, and that we need to think of individuals that are harmed by those practices as survivors of reproductive violence. So since the beginning of the Israeli military operations in Gaza, following Hamas's October 7th, 2023 attack on Israel, the UN, humanitarian actors, and civil society have warned about and documented attacks on health facilities by Israel, including specifically those providing reproductive health care, restrictions on food and medical supplies, the continued displacement of Palestinians in Gaza, and they have consistently raised concerns about the devastating harm caused by these actions to the reproductive health of people in Gaza. In September 2025, the UN Commission of Inquiry that's focusing on Israel and Gaza and other Palestinian territories published a report based on data largely collected in 2024 and early 2025, finding that Israel's attacks on facilities providing reproductive health care and restrictions on food and medical supplies were intentional and systematic and resulted in devastating harm to reproductive capacity in Gaza, and finding this to be reproductive violence. Despite these warnings, reports have consistently indicated that since early 2025, Israel has continued to further restrict access to humanitarian aid in Gaza and continue to target healthcare through direct attacks and bombardments of health facilities and sweeping restrictions on medical supplies being allowed to enter Gaza. And the data is indicating poor reproductive health outcomes in Gaza even following the COI's report. For example, between May and June 2025, the Palestinian Military of Health reported a 41% decrease in the birth rate in Gaza compared to the same period in 2022, with a significant increase in miscarriages and premature births and low birth weight cases. And this data raised questions about whether and how the conflict may have impacted these birth outcomes. And that was part of what we were really investigating here. So we were looking at the impact of attacks on health and restrictions on food and medical supplies on women of reproductive age, including those that were trying to conceive, that were pregnant, postpartum, and lactating, as well as on their newborns from January to October 2025. And we sought to determine specifically the foreseeability and preventability of reproductive health harm from these tactics of war. So how much should the government of Israel have known about the impacts, and did the impacts that were predicted by UN experts and others actually come to manifest? And that really gets at intentionality. Our analysis is based on 78 interviews with health professionals who went to Gaza on short-term medical missions, analysis of the record of warnings issued concerning risks to reproductive health as a result of the tactics of war used in Gaza by the UN and by others, 23 reports of direct attacks on reproductive health facilities in Gaza from January to October 2025 collected by Air Wars, and the established medical literature on the known reproductive health harm resulting from acute malnutrition and the denial of proper prenatal and postpartum care. So really looking at the medical literature. And what we found was that malnutrition and lack of access to care led to infertility, miscarriages, complications, and death. A nurse who worked in Gaza shared, "We clinically saw it in women not having periods because they're so severely malnourished. We saw it in women who are having miscarriages, women who weren't lactating, because when you're pregnant or lactating, your caloric intake requirement increases. And these otherwise healthy women with no comorbidities were not producing any breast milk, even though they had in previous pregnancies. Similarly, pregnant women develop critical complications during pregnancy, some of which directly resulted from acute malnutrition, and some of which were made more difficult to manage due to acute malnutrition. And this resulted in observed increases in miscarriage and preterm births. Barriers to maternal health care also led to suffering and death. Clinician after clinician documented how women who became pregnant experienced preterm and prolonged labor, but lacked the necessary medical supplies to ensure safe labor and delivery. Mothers struggled to feed newborns and infants due to impeded lactation. Where breastfeeding was not possible despite clinical support, infants required then access to age-appropriate therapeutic formula. Yet, Israel imposed severe restrictions on bringing baby formula into Gaza, further limiting clinicians' ability to ensure babies had the nutrition they needed to survive and avoid malnourishment. A healthcare provider who visited Gaza following the complete blockade in May 2025 of aid described the instructions they received from the IDF via WHO, including not to bring baby formula, to ensure they were able to pass Israeli checkpoints and enter Gaza. And they said, we were specifically told not to bring baby formula with us because it was not allowed. We were specifically told not to bring antibiotics or pain medication with us because it is not allowed by Israeli soldiers. And if we're caught, we risk being denied entry. Compounding this, attacks on reproductive health facilities, limited access to care to prevent and treat pregnancy and neonatal complications and health harm. For over 2 years, Israel had repeatedly attacked hospitals providing broad reproductive health services, as well as more specialized units. The attacks, for example, destroyed all facilities providing infertility treatment, and further limited the availability of specialized services that were already actually quite limited before October 7th, 2023. And then clinicians highlighted how malnutrition actually was then made more difficult to treat due to limited beds in blockaded facilities, damaged hospitals, and inoperable facilities, and barriers to accessing medical supplies. An interview neonatologist shared the compounding effects of malnutrition, stress, and attacks on healthcare on health outcomes for premature babies, saying, I saw a lot of premature babies. Babies born anywhere from 28 to 33 weeks. We had a baby that suffered a brain injury from lack of oxygen during delivery. That baby did not get the treatment that the baby needed or standard of care because they didn't have the right equipment to take care of that baby. And also because Al Shifa, the hospital, which would have been where the baby would have been transferred to, was destroyed. Between January and October 2025, PHR and GHRC found that health facilities providing reproductive health care were repeatedly attacked, blockaded, and raided. And this is a particularly chilling testimony to me, which was an interviewed health provider who described what Kamal Adwan Hospital looked like after being attacked and raided by Israeli forces. And they said, it was just toxic. There is this poisonous smell in the air, acrid smoke still hanging, everything burned and charred, crunching medication vials under our boots. Kamal Adwan had one of the only functioning neonatal ICUs in the north at the time. We walked through the neonatal ICU, which hadn't been burnt, but had been destroyed. And there were incubators that had been smashed and strewn about. The whole facility was destroyed. And that really prompts you to ask a question, why is the military going in and destroying incubators? For what purpose is that occurring? So our analysis really determined that the suffering and death of pregnant, postpartum, and lactating women and newborns were foreseen and foreseeable, that the warnings that had been issued were deliberately or recklessly disregarded. And this resulted in an avoidable crisis that harmed women's reproductive autonomy by harming their ability to menstruate, have healthy pregnancies, give birth safely, and breastfeed, and caused infants to die of dehydration and malnutrition. And we found that these tactics of war constitute reproductive violence. So I'll just say very, very briefly, because this is a panel that's on justice, to actually think about the law behind this. And part of what we examined here, we examined ICL, international criminal law, international human rights law, but also international humanitarian law, and looked at the special protections of pregnant women and children in international humanitarian law, looked and examined the responsibilities of Israel as an occupying power. And then also looked at the law around attacks on health facilities, which, as you all know, is prohibited in international humanitarian law. And in the rare cases where such attacks are permitted, they do need to occur in line with core principles, including the principles of precaution and proportionality. And proportionality in particular requires assessing the harm that would be caused to civilian life, including the reverberating impacts of these attacks. And what we're articulating here is that there needs to be an analysis of the gendered impacts. And I think the International Committee of the Red Cross put it really well in the new study they put out recently, which recognizes that failing to recognize that an attack on the only hospital with gynecology and obstetric services, in addition to other healthcare services, such that the damage to it would spike mortality, particularly amongst women and girls, is actually a failure, right, of doing a proper proportionality analysis. So that's just one example of how we think about international humanitarian law and the protections of reproductive autonomy. So I'm happy to talk a little bit more about what justice might entail in the Q&A and to think about what's actually needed in this moment. But just to say that this is another frame where I think that same value of reproductive autonomy is being violated in a systematic manner that really needs to be examined.
Thanks so much, Payal. I hope that during the Q&A, the audience will bring you to that question of what justice might look like in that context. And yeah, thank you for sharing some of the quotes from the report. I think those are difficult to hear, but so important to give, that color to what's happening in Gaza. So thank you, and thanks to PHR and the physicians involved in the report for putting that together. Now I will turn to Maria Cecilia to ask about a different context on a different continent in a different time period, to speak about what happened in Peru in relation to reproductive violence and recent, I'll just leave it as maybe recent justice developments in that context, and with a different kind of set of laws and legal systems. So over to you, Maria Cecilia.
Thank you, Emily. Thank you so much. And thank you to UN Women for hosting us. And also thank you to the Global Justice Center and all the other co-sponsors of this event for inviting the Center for Reproductive Rights to be here. So I'm going to talk a bit about forced sterilizations in Peru, which is one of the most serious forms of reproductive violence that have occurred in Latin America in the past years. So I will first address the context in general, and then I'll emphasize a bit on the Celia Ramos case, which was recently decided by the Inter-American Court of Human Rights last week, actually. And I will close with some important reasons of why we consider that this case is a great example of access to justice in a situation of reproductive violence. So first, it is important to situate what happened. So all of this took place between 1996 and 2000 during the government of Alberto Fujimori in Peru, during which what was called the National Program on Reproductive Health and Family Planning was implemented, and which was actually directed specifically to indigenous, rural, and impoverished women, and in the context of which at least 7,000 women were forcibly sterilized. So we have the number 7,000 because that's the number of victims that are currently registered in Peru as victims. But there's also a bigger number, which is 272,000 women who were subjected to a procedure of sterilization. So it's actually a very massive situation. And what has happened in Peru is that accountability for these violations has been extremely limited. So there was a truth commission that took into consideration facts that occurred during the Peruvian armed conflict. And even though the commission issued several important statements and recommendations concerning, for example, the impact of the armed conflict on indigenous groups, and also the impact concerning, for example, sexual violence, the Truth Commission did not take into consideration reproductive violence, and not even mentioned forced sterilizations as something that had happened during the armed conflict. In addition, there were several Congress investigations, or there have been several Congress investigations throughout the years, but there has been a generalized context of impunity surrounding these facts. So no real investigation has been carried out on this matter. So thousands of victims have been seeking justice for decades in Peru concerning forced sterilizations. So then we have specifically the case of Celia Ramos, who was one of these women. In 1997, Celia, who lived in a rural area of Peru, when she was 34 years old and a mother of 3, she was pressured by medical personnel mainly to undergo a sterilization. She went to a medical post to get dental advice, and she was, since that moment, pressured to get sterilized. In addition to this, the medical procedure was carried out without adequate conditions or proper medical care, and Celia passed away as a consequence of the procedure. Celia's family brought the case before the Peruvian justice, but the 2 main investigations that were dealing with this case were closed, and this was obviously affected by the generalized context of impunity surrounding the forced sterilization situation. And therefore, her case was eventually brought before the Inter-American Court of Human Rights. It was first brought before the Inter-American Commission. The petition was submitted in 2010, and then the case was sent to the court in 2023. So this case was litigated before the court by Peruvian organization Demus, CEGIL, and also the Center for Reproductive Rights. So the Inter-American Court's decision represents a key stage in victims of forced sterilization's access to justice for several reasons. So I would like to highlight some of the main reasons why we consider that this is a great example of how reproductive violence is being brought before justice. But of course, there's many more details in the judgment that we can delve into in case anyone has any more specific questions. So first, I think it is very important to highlight that the decision acknowledges that the national plan implemented by the Peruvian government, the Program on Reproductive Health and Family Planning, was a state policy directed to massively sterilize indigenous, rural, and impoverished women. The state has constantly denied this. The policy actually says something different, but it's a very, very important conclusion that the court arrives to when it states that it was clearly a state policy designed to do this. And also that officials were given incentives to recruit women for sterilizations. They were given rewards if they met targets. So officials were actually pushed into getting women to get sterilized. So this is a very first important aspect of the judgment. And second, it also states that in Celia's case, her consent was obtained through coercion. So it specifically says that in this case, the standards, the Inter-American standards for uninformed prior, full, free, and informed consent were not met, and that therefore her case is one clearly of forced sterilization and also a form of reproductive violence. So this is one of the main highlights of this case for us, because one of the big objectives of this case was to frame the facts under the category of reproductive violence, and specifically as a form of gender-based violence, reproductive violence as a form of gender-based violence that impact reproductive autonomy. So this was a very important element of the case, and it builds on the center's prior work on the Colombian armed conflict, in which we have worked to ensure that both the Truth Commission and also the Special Jurisdiction for Peace also recognize reproductive violence as it occurred, but also that it names reproductive violence as such. So the use of this concept, of course, seeks to emphasize the underlying value and the underlying right that is being violated or infringed. And and to highlight that it is, of course, connected to a broader context, as Emily was saying at the beginning, of reproductive autonomy, but negation of reproductive autonomy, and also of gender stereotypes and power dynamics that affect everything that goes around concerning reproductive health. So naming is relevant, and we were very excited to see that the court actually took into consideration the use of this category. It is the first time that the Inter-American Court of Human Rights uses the concept, and it actually connects it also to the Belém do Pará Convention, which is the Inter-American Convention on the Prevention of Violence Against Women, which of course the treaty does not mention reproductive violence, but now it is possible to connect it to this treaty thanks to this judgment. And another point I want to make about the use of the concept is the fact that even though when the case was being litigated, it was emphasized that these facts took place in the context of an armed conflict, the court does not analyze whether or not an armed conflict was taking place. But this didn't matter to us, because what was relevant to us was to make sure that the category was used, no matter if the court decided that there was an armed conflict or there wasn't an armed conflict. We believe that the category can be used outside the framing of the armed conflict. And that is why we also consider that it is a very successful decision in this sense. Just to highlight, of course, something that is also very important is that the court acknowledges that Celia was a victim of intersectional discrimination because of her gender, but also because of her economic situation. And also it takes into account the level of education she had. And it connects to the fact that the lack of consent was impacted by underlying stereotypes and power dynamics. And third, I want to briefly highlight some of the important structural remedies that the court orders in this case, because of course, they're the ones that we believe are going to contribute to ensure that this doesn't happen again. So first, it refers explicitly to a registry on victims of forced sterilization that exists in Peru. So it asks the court the court asks Peru to register all victims of forced sterilizations, even including those who passed away because of the proceedings. It also orders the state to design, activate, and implement a policy to effectively grant remedies to all victims of sterilization. And something which I believe is really, really important, it asks the state to ensure participation of victims in the design of this policy. So victims have to be included in the design of whatever the state is going to come up with. Also, there's another important structural remedy concerning the protocols of prior, full, free, and informed consent. I know it in Spanish, so it's hard to translate it to English. The court asks the state to revise and update these protocols so that they match the standards established in the judgment. And also it asks the state to disseminate the protocols so that they are well known everywhere, including medical schools, so that students can also learn what consent is and what it means. And it asks the state to create a guide for patients on informed consent, which should be translated to different languages. And this is very important because, again, most of the victims in the forced sterilization situation in Peru were indigenous women who don't speak Spanish, who spoke Quechua. So it is important that all the protocols are also translated and that the guide for the patients are translated into their language. And finally, I'll close. The state was also ordered to design and implement a national policy on sexual and reproductive rights. So this needs to take into consideration the consent standards, also a gender and intersectionality and non-discrimination perspective, and ongoing training for healthcare providers. So we believe that the court's decision brings long-awaited justice for Celia and her family, but it also goes beyond the case in the sense that it represents justice and sends a powerful message to all the women who are victims of this policy in Peru. And we are happy to see that in times in which international law is being questioned so much and sometimes feels like it doesn't help much, this gives us a bit of hope to continue doing our work. So thank you.
Thanks so much, Maria Cecilia. When we were designing this panel, we didn't, of course, know the outcome of the judgment. Yeah. And I'm thinking, oh, it might have been nice to have you go last because that's such an incredible story. And now I'm going to put Richard on the spot to speak about Afghanistan in a moment. But yeah, I mean, it's really incredible to hear the outcomes of all of the, I'm sure, years, decades of legal advocacy and representation that the Center for Reproductive Rights and your partners have been doing. So congratulations to you, and it's an amazing victory, and not just for Celia, but her family, but also for the victims and survivors across Peru and across the region who will be affected by this. And I was looking at the Global Survivors Fund about the piece about reparations, I think is really incredible and so important. And now when I try to think of an example of a guarantee of non-repetition, I will think of the change in consent that's required as a result of this case. I think that's a really incredible example of guaranteeing non-repetition. So anyway, I have a lot to say on that one, apparently. We'll come back to it in the Q&A. I want to now turn to Richard Bennett. If you're there, Richard, I think you've taken your video down for the time being, but if you make sure that Richard's there before is he there? He is there, okay.
I'm here, yeah.
Hi, Richard, thank you. So, Richard, turning to the situation in Afghanistan, moving back in the direction of a context where we don't have justice at the moment, could you share with us in what ways do the Taliban's restrictions on women's rights in Afghanistan amount to systematic reproductive violence, and what pathways do you see for justice? Over to you, Richard.
Thank you very much, Emily. Many thanks to the organizers and also to the co-sponsors, Australia, Slovenia, and the UK, for convening this important discussion. And I feel very honored and a bit overawed to be on a panel with such amazing experts that have spoken before me. I also like to acknowledge and thank my colleague, Laura, who has been working with me on this issue. So Afghanistan, when we speak of reproductive violence, many of us might think first of its most visible and brutal forms, such as some of the previous speakers have described. And these acts rightly shock us. They're immediate, graphic, and undeniably violent. But reproductive violence doesn't only occur in moments of open conflict or direct physical violence. It can unfold more quietly, creeping in through laws, decrees, and policies that, as in Afghanistan, systematically strip women and girls of control over their bodies and reproductive autonomy. Since the Taliban returned to power, August 21, the lives of Afghan women and girls have been reshaped by policies that not only restrict rights, they undermine dignity, health, and agency. And let me be clear, these policies are intentional and systematic. In a recent report I wrote for the Human Rights Council on the right to health, we've examined this crisis in detail, and under Taliban rule, access to essential health services, including reproductive health care, has been severely curtailed. Women and girls face multiple overlapping barriers. In many key areas, many geographical areas, they must be accompanied by a male guardian and adhere to very strict version of hijab just to seek treatment. And this prevents them from traveling independently, or means, and we've had many cases given to us of this, they're denied entry at the gates to health facilities because they're not dressed appropriately in the opinion of the gatekeeper, and or they don't have a male escort. Gender segregation in hospitals for both patients and health workers further undermines availability and quality of care, including for gender diverse persons. So access to contraception and safe abortion, the latter already very limited before 2021, has become even more constrained. For example, women seeking long-acting contraceptive methods often require their husband's consent. Women working in the health sector in Afghanistan, and actually this is one of few areas where women still are able to work, face extensive constraints, as do organizations attempting to provide health education or undertake awareness-raising activities. And meanwhile, the Taliban has banned medical education, including ongoing continuing education for women, shutting off the pipeline of future female health workers and threatening the viability of the health sector as a whole. Even before the Taliban takeover, Afghan women faced serious obstacles in exercising reproductive rights. And it's important to acknowledge the impacts of geography, chronic underfunding, and reliance on international aid. However, the current crisis, the downward trajectory, can't be explained solely by resource constraints. It is the result of the Taliban's deliberate and regressive methods. These strike at the core of bodily autonomy, directly and indirectly undermining women's ability to make free and informed decisions, including about whether, when, and how to have children. These policies constitute intentional and discriminatory infringements on rights to privacy, bodily integrity, family life, and the highest attainable standard of health. Taken together, they amount to systematic reproductive violence. This form of violence may be less visible than some others in Afghanistan than in some other places, but it's no less harmful. The consequences are preventable maternal deaths, lifelong reproductive health complications, psychological harm, and intergenerational impacts on child health. They're foreseeable and they're preventable. And reproductive violence in Afghanistan can't be separated from the broader framework of gender discrimination and domination entrenched in law and practice. Girls are barred from secondary and tertiary education. Women are restricted from many forms of employment and are largely excluded from public life. These measures amount to crimes against humanity, including persecution on the ground of gender, which is what I and others have said, including the International Criminal Court, and are well characterized as gender apartheid. Then in my report, my recent report, I conclude that violations of the right to health and acts of reproductive violence may also constitute indicia of other international crimes and certainly warrant further investigation. I want to not only speak of reproductive violence, but as you hinted, Emily, also reproductive justice. In consultations my team and I have conducted with Afghan women last year, we asked them, what do justice and protection mean to you in Afghanistan? The responses were varied. Justice means different things to different people, but to be clear, efforts to investigate and prosecute international crimes must continue, and the international legal framework must evolve to fully recognize reproductive violence and codify the crime of gender apartheid, as I mentioned. Yet, for many Afghans, particularly Afghan women, justice extends beyond legal accountability. It includes recognition of harm, redress for inequality, meaningful inclusion in decisions affecting their futures, and transformation of discriminatory structures. It includes the realization of economic, social, and cultural rights, such as access to education, work, healthcare, and an adequate standard of living. Reproductive justice, therefore, requires more than condemnation. It demands sustained and flexible support to civil society, particularly women-led organizations that continue to provide services and advocacy, often under great risk and pressure. It requires also confronting and reversing catastrophic international funding cuts that have shuttered clinics, reduced maternal health services, and weakened protection mechanisms. And above all, it requires restoring survivors' rights, dignity, this point was made repeatedly, and agency in their entirety while placing the people of Afghanistan, especially women, girls, and marginalized groups, at the forefront of all efforts, ensuring their voices, expertise, and priorities shape policies and solutions. So reproductive violence in Afghanistan, as elsewhere in the world, is inseparable from the broader struggle for justice, accountability, and gender equality. Thank you.
Thanks so much, Richard, for those comments. I have so much to say also about what you've shared from Afghanistan, but I'm also thinking as moderator that actually you've done a great job of linking to our previous panelist by encouraging us to think about how justice can extend beyond criminal accountability to the realization of economic, social, and cultural rights, and that justice is more than condemnation. It's also about funding for women-led organizations, and generally funding for gender equality. And then you've also linked us to our next panelist, Tess, by highlighting the demands of Afghan women to codify gender apartheid as a crime against humanity and also expand legal protections and framework around reproductive violence. And Tess, I have a question for you. The Global Justice Center has been very active in working around the Crimes Against Humanity Treaty, which is currently in, I guess, the pre-negotiation phase. So something that's kind of been increasingly on our agendas here in New York with the preparatory committee meetings a few weeks ago. But my question for you is, how can we strengthen recognition of and access to justice for reproductive violence? What other norm development do we need to ensure this recognition? And what role can the Crimes Against Humanity Treaty play in this recognition for survivors and their access to justice?
Thank you so much, Emily, and thanks to everyone who helped to organize and co-sponsor, to Australia, the UK, and Slovenia, and our wonderful hosts at UN Women, and my incredible co-panelists. It's a very hard set of presentations to follow, but I will do my best to synthesize some of the messages that we've heard and bring them forward into talking about how we can ensure that the norms around reproductive violence that we need are developed and are codified in international law. An understanding of reproductive violence as a core form of violence, as a core international crime, so that we can extend access to justice for survivors across the board. So we've seen from my co-panelists a variety of forms of reproductive violence, and ranging from the very acute to the more systematic. And these examples are incredible examples of the hard work of documentation of reproductive violence, which is particularly challenging because this form of violence has not always been recognized as a form of gender-based violence, or indeed as a violation at all. Reproductive autonomy, the violation of reproductive autonomy, tends to be highly normalized. So it's a challenge to recognize this form of violence, and that recognition is needed in order to ensure that these violations are documented and that processes towards justice can be initiated. But there's also a need for documentation to ensure the recognition of the harms. So you have a bit of a catch-22 that can arise. But we are seeing this increasing momentum towards the recognition and the development of this norm, and that's what some of these this incredible work shows. And the Cecilia Ramos case shows what is possible once that recognition reaches a critical mass. So the importance of developing this norm and ensuring that reproductive violence is recognized, I think, is apparent from all of these examples. But just to take a quick step back, I want to return to the definition of reproductive violence that we heard at the very beginning, that it is gender-based violence that targets reproductive autonomy, including acts or omissions that interfere with reproductive autonomy, or that are violence that is enacted on a person because of their reproductive capacity. Now, the importance of recognizing this form of violence is across the board, has great impact. So first, recognition in international law of this form of violence is important for acknowledging that this conduct is wrong and ensuring that it is taken seriously and seen as the potential threat that it is. As we saw from Weiwei's presentation, the way that reproductive restrictions tend to escalate. So they may start with restrictions on birth or on birth registration, and then escalate to more acute forms, and then have a very long tail of impact that echoes across generations. So it's essential to ensure that those things are recognized. It's also essential, as we've seen, to ensure that victims can seek justice both in the criminal legal sense and through civil and reparations measures, and to ensure that services are available to survivors and that they are delivered consistently and with full funding, as Richard was alluding to. We do see an increase and an improvement in the recognition and documentation of this form of violence, as we've seen today, but also from other, excuse me, commissions of inquiry, including the Commission of Inquiry on Israel and Palestine. And there's a building body of law in human rights law that recognizes these forms. We've also seen recently CEDAW has issued an amendment, or sorry, an addendum to their General Comment 30 on women, peace, and security, which highlights the deepening recognition of reproductive violence as a form of SGBV and its crucial role in the women, peace, and security agenda. So all of that brings us to the next great opportunity for norm development and to really see reproductive violence codified in a irreversible way in international law, and that is the Crimes Against Humanity Treaty. So as many of you know, this treaty has been long in the making, but it's reached a critical point now with a time-bound process that the UN General Assembly has mandated. As Emily mentioned, the first preparatory committee took place in January of this year, and we'll see another preparatory committee next year, and then 2 more years, 2028 and 2029, we will see the actual negotiation of the text of the convention on the basis of draft articles developed by the International Law Commission. This is an incredible opportunity for justice across the board. This is an opportunity to reaffirm progress that was made in the development of the Rome Statute, which itself was a landmark in international justice. This treaty will be the only standalone treaty on state obligations to prevent and punish crimes against humanity, and it will support the Rome Statute by clarifying those state obligations. Those are crucial for protection and prevention, not just criminal response to atrocities that have already occurred. So this is an opportunity, again, to codify the growing recognition of reproductive violence as a broad category of crime that goes beyond the forms of reproductive violence that are already codified in the Rome Statute and which were carried over into the draft articles. So forced pregnancy and enforced sterilization are already codified as crimes against humanity under the Rome Statute. But as we've seen from the panel, these are sort of the most acute eruptions of this form of violence, which are often preceded by and followed by a vast spectrum of other forms of reproductive violence. We saw the first ICC prosecution of forced pregnancy, which affirmed that the value being protected by the codification of forced pregnancy was and is reproductive autonomy. And we just saw the first recognition of the same under enforced sterilization in the inter-American system. Notably, there's never been a prosecution for enforced sterilization under the Rome system. So we're seeing some progress, but I also want to highlight that it's taken a long time. For example, in the Cecilia Ramos case, that process was extremely long, in part because of the lack of recognition or the reluctance to recognize that this form of sterilization without consent constituted enforced sterilization, which constitutes reproductive violence, which is an international crime. And so clearly outlining that chain is really important for ensuring all of the values that I alluded to before. There are a variety of proposals by civil society that have been advanced to make this possible in the Crimes Against Humanity Treaty. I'll highlight one that is to include the term reproductive violence in the draft articles and in the eventual treaty text. An alternative proposal to that, both of these we support, by the way, in the alternative, would be to codify the protection directly of reproductive autonomy and integrity as the value that's being protected by the crimes under Article 21G, I believe. So those are two opportunities. There's also the proposal to codify gender apartheid, which we think is essential for furthering the recognition of the systematic nature of many of these crimes. I want to wrap up by inviting all of your participation and help with this process, because the Crimes Against Humanity Treaty process, as I said, is an incredible opportunity to ensure that progress is strengthened and codified and reinforced. And it's in a moment of, as we all know, very dire need and backlash. So there are many opportunities for people to join in and help with this codification process and to bring their priorities to the international legal community. The first of which is states will be submitting their written comments by April 30th on the draft articles. And we hope that many of those comments will support the codification of reproductive violence or the protection of reproductive autonomy. We know we have some state friends in the room, and we're very much looking forward to seeing their comments. After that, there will be, as I said, negotiations in 2028, 2029. Civil society is organizing around those through coalitions, networks, and events, including 3 events this week on March 12th and 13th. And we can provide more information to attendees if you're interested. We hope that you can join us for many of those events. So let's just see what's possible. We saw what was possible in the Rome Statute, and let's go even further. Thank you.
Thanks so much, Tess, for giving us something to look forward to and work towards. I think drawing inspiration maybe from the Peruvian context and thinking about how a treaty could be used to pursue accountability for the violations that we've heard about from our other panelists, and to prevent violations in the future. So thank you. I would like to open the floor for questions and comments. If you know me, you know I have questions for the panelists, which I will not hesitate to use, but I encourage all of you to please, I think Laura has a microphone. First, I would love to give the floor, though, to one of our co-hosts, co-sponsors for this event, the Global Survivors Fund, Esther Dingemans, the executive director, if you don't mind giving Esther the mic first.
Thank you very much, Emily, and thank you to all the co-sponsors. And Tess, for those wonderful remarks. And you have made me change a little bit about what I was going to say, because I wanted to talk about Colombia. That's not a situation that's not been addressed yet today, but I do think there's remarkable positive progress there as well in recognizing reproductive violence and integrate it in the justice system and accountability. But I feel with your comment now, maybe I don't want to go too deep into this situation, but make another comment about reparation. But just on Colombia, one thing, good news. This week or at the beginning of this month, 7 senior FARC commanders recognized their responsibility for reproductive violence. And that is really a breakthrough that I hope also will encourage other situations. I want to say one thing. It was International Women's Day, and the work in Colombia is really thanks to activists, women's rights organization. Richard, I want to echo you in shouting out for them, and not in the least survivors themselves, who have really, really fought for the recognition of reproductive violence in the conflict in Colombia. We work in Colombia on case 05 under a memorandum of understanding with the special jurisdiction of peace. And they have asked us to co-create with survivors of forced abortion and forced contraception and forced pregnancy to co-create reparative measures. So what is really meaningful to survivors when it comes to redressing or addressing the harms caused by reproductive violence. And it will, of course, not surprise you that the main message that survivors have is any measure needs to be long-term, really, really long-term. whether it's health, whether it's psychological care, whether it's community work, whether it's economic empowerment, which are all very important components of the reparation measures, but it needs to be long-term. And with that, I cannot leave the room without talking very quickly about 3 contexts that have not been mentioned yet today. One is, of course, Sudan. In the work that we're doing with survivors in Chad at the moment, but also supporting organizations in Sudan, you know this, 40% of the survivors are girls under 18. So really targeted because of their reproductive age. And this is not new. This happened 20 years ago as well in the previous genocide. Those girls will now be in their 30s, 40s. And we have no idea for Sudan how this has really impacted their lives, their development, their relationships. So there's very little, the research that you're mentioning, Payal, really, I know that you're working also in Sudan, so this also needs to happen there. Another context where we're working is Ukraine. We have provided, together with the government and civil society organizations, reparation for survivors of conflict-related sexual violence. Many of them are men who were targeted, their genitals were targeted very specifically. We have no idea how that's going to impact their procreation capacity. And the last situation, Syria. Already a few years ago, we were approached by a group of women, survivors of detention, who were saying many of them had difficulties getting children, becoming pregnant, and developed also various forms of cancers. It was very difficult. No one has really, no one has really investigated this situation yet. And now, of course, with the toppling of the regime, I think there's an opportunity to really look at the reproductive violence that was committed in the detention and outside, but especially in the detention center. So I really want to call on all of you to keep those 3 contexts also on your radar. When it comes to reparation, what we know, it needs to be long-term. Reproductive violence, of course, affects people completely different over the span of their life, in teenagehood, in intimate relationships. What do we really know about that during motherhood, but also during menopause and at elder age? This is really long-term sustained work, not one-off compensation or interventions. So that's my contribution for today. Thank you so much, everyone.
Thanks so much, Esther, for bringing a few more contexts into the conversation and also types of reproductive violence, and that reminder of the long-term impacts and the importance that we address those impacts with long-term reparations and support to survivors. And also the shout out to women human rights defenders and women-led civil society organizations for their leadership on this issue and pushing the rest of us to come alongside. I will not hesitate to ask my own questions to the panel, but please, does anyone in the room have a question that they would like to ask? Yes, Amrita.
Just a small one. I was just curious around the negotiating for the Crimes Against Humanity Treaty, and just recognizing that some of that is also, particularly with respect to gender apartheid, has a lot of other political dimensions. And so I was curious, firstly, to what extent do you see the politicization of these types of issues in generally play into the sort of negotiation space or contract? And I think secondly, what sort of strategies are useful overcoming? And I think I speak specifically as well to the issue of gender apartheid, recognizing there's, the Afghanistan context is probably the most politicized context in response with respect to those negotiations as well, and the sort of the coherence or lack of coherence between state positions on engagement on different topics across the board. It's a little bit broader than the specific justice question, but I think one that really goes to what's required politically and strategically to really shape the negotiation so that threshold is as high as possible.
I'd be happy to take more than one question before putting Tess on the spot. Maybe I'll ask my own question about the Celia Ramos case. what came to mind was just wondering, it sounds like such an incredible judgment. Is there anything that you would have added or that you didn't see that was there? Would love to hear your thoughts on that. Okay, Tess, first on crimes against humanity and political movement.
Yeah, thank you. And thank you, Amrita, for the question. It's definitely a very challenging moment to be negotiating an international criminal law treaty and be pushing for gender justice within that. It's a difficult moment because of global gender backlash, we don't have to recite all of the challenges that we're all very familiar with. But I also think that it's a very interesting moment because we do see that gender is instrumentalized very actively, very readily by folks whose agenda is actually more focused on, rolling back human rights broadly, entrenching authoritarian power, and recognizing that instrumentalization and articulating it, I think is crucial for undercutting that the persuasiveness of that tactic, because it's really a very shallow engagement with gender, with human rights, with law that is kind of being drummed up to oppose these measures. The other thing I'll say is that I think that the issue of reproductive violence in particular touches on and invokes, as we've heard from Pyle, for example, invokes obligations and moral responsibilities and norms that states have been affirmatively signing up for hundreds of years because of the recognition of the importance of reproductive capacity in human relations and human flourishing. So the protections for pregnant women in IHL go back before the Geneva Conventions. This is a set of norms that people have always recognized around the world. We need to remind states that they have signed up for these, that they have the moral obligation and the legal obligation, and that it really shouldn't be so controversial to recognize the importance of ensuring reproduction and care, and that the core of human flourishing in that context is about autonomy, integrity, and dignity. It's about being able to make your own decisions. So to me, it's a very shallow way that this is being instrumentalized. So I think we want to try to remind states of what this is really about and not let them get distracted by those tactics. On gender apartheid, I will also say that I think the groundswell of support for the codification of gender apartheid among Afghan civil society is really important. And what we need is continued civil society support, especially from the ground around the world, especially in contexts that have been impacted by apartheid, by the origin of the crime, and that are currently under apartheid conditions, including Palestine and the Rohingya in Myanmar.
Thanks, Tess. Before I hand over to Maria Cecilia, just while we're on the topic of gender apartheid, Richard, I don't necessarily mean to put you on the spot on this if you don't have anything to add, but just wondering if you have any thoughts on Afghan women's calls for the codification of gender apartheid in the treaty and political pushback on that, if you have anything you want to add to what you shared earlier.
I think actually Tess has covered it really well and probably more diplomatically and more nuanced than I would. But I think what I would say is that from what I can tell, I mean, certainly there is a groundswell from Afghan women. We see it all the time. I'm on a lot of social media with Afghan women inside the country and in exile, and it's a very strong campaign, strong lobby. What I would just maybe Tess was hinting at it is that finding support from other countries that have experienced apartheid, helping them understand the situation that women in Afghanistan are facing, by that understanding being promoted by Afghan women, I think super important. And I'm thinking in particular about South Africa, Namibia, and Palestine, actually. So I think there are certain triggers that may help get fence sitters, if we call them fence sitters, more on board. And I would think that in coming months and next year or two, it would be important for Afghan women to be supported in that endeavor. Thank you.
Thanks, Richard. Okay, and again, before I give you the mic, I also want to make sure I give a last opportunity to speak to YY and Payal. So while Maria Cecilia is sharing her response to my question, I'm curious, Payal, we didn't come back to the question about justice for victims and survivors of reproductive violence in Gaza, and YY, if you have anything to add on kind of the future of justice and accountability in your context as well. So, okay, now to you, Maria.
Great. So thank you. So again, I'll say that this is a great judgment and we are really proud of the outcome, but there are two elements that I think would have been great to also see in the decision. So first, the court does not say anything about whether the facts constitute a crime against humanity. So this was a specific interest, especially of our Peruvian co-litigators, because that's the way they have framed these facts within in Peru and also in other spaces. But what the court says is that it will not say whether or not it is a crime against humanity. It doesn't say that it's not. It just say that it will not talk about that. And this may be connected to the fact that the court has been, and the system in general has been under a lot of pressure lately, and that they may feel like they don't want to overstep their role because they are not an international criminal tribunal. So they should not be speaking about crimes against humanity, even though they have done it in the past. But perhaps this relates to the specific current context. But connected to this, there's two important things to highlight. So first, that the court does say that these facts are or constitute serious violations of human rights or grave violations of human rights, which is a specific category used by the court, especially in connection to fact patterns that have occurred during during military dictatorships and armed conflicts. And this is very relevant because the consequence of categorizing something as a grave violation of human rights under inter-American jurisprudence means that the states cannot apply statute of limitations to the facts, and they cannot apply amnesty laws either. So in a practical sense, it is very similar to saying that they constituted crimes against humanity, but the court sort of moves away from stating crimes against humanity explicitly, but rather just says serious violations of human rights, which we also think is a great thing that they did, because previously this category was mainly used for enforced disappearances, torture, extrajudicial executions. So the fact that they're using it for forced sterilizations is also really great. And also something that is very relevant is that the president of the court, Judge Nancy Hernandez, actually issued a concurring opinion saying that she thought that the court should have said that the forced sterilizations were a crime against humanity. So that would be one thing. The litigation had great experts and amicus briefs supporting this argument. So we believe that there is no doubt that they could have been categorized as such. And the other point that I think would have been great to see in the decision is a higher emphasis on how indigenous and rural women in Peru are in a situation of structural discrimination, because the court has also used that category to refer, for example, to the situation of Brazilian Black women. And I feel like they could have used the category as well to refer specifically to indigenous and rural women in Peru, because of course this is directly connected to colonialism, and it impacts access to reproductive health and rights in other aspects. So for example, the center is currently litigating another case concerning a Peruvian indigenous woman who was a victim of obstetric violence. This is also before the inter-American system. So it is connected in a way. So it would have been nice to see the category of structural discrimination explicitly. It does say it on the sides, but it would have been great to see the definition there.
Thank you. Great. So even a good judgment can be improved upon. Yeah. Okay. I don't know. Do you have a preference in terms of order? You want to go first, YY, on just 2 minutes, if that's okay?
Sure, sure. Okay.
Going to run over.
I will try to brief as I can. So in the case of Burma and Rohingya, obviously the specific acts of reproductive violence, which is limiting or restricting birth rates, is constitute the act of genocide. So, and it happened throughout the period time systematically. And for us, it is absolutely an obvious violations of the Genocide Convention. And again, broader acts of reproductive violence, such as maybe forced pregnancy and rapes, other forms of sexual violence, deliberately limiting access to reproductive health. All of this can also constitute to the other acts of genocide, such as deliberately causing bodily or mentally harms to groups, or inflicting their physicals and mental sorry, let me just go back to that, inflicting on the group conditions of life calculated to bring about the physical and mental destructions of a group in whole or in part. Article 2C of the Genocide Conventions. And although they are not enumerated, they could fall into those categories of the Genocide Conventions. And that's what the Gambia legal team is arguing about in the ICJ genocide case. With that being said, the reproductive violence as a violence or as a crime is not enumerated itself in the Genocide Convention. So I think like strongly and heavily codifying that acts of the reproductive violence, as well as specifying of each act to the crimes against humanity, would be a great value to the international law and access to justice for the communities suffered. And when it's come to the Rohingya, I think we definitely want to see the criminal accountability of all the violations of reproductive violence, and not only at the International Court of Justice, but also in ICC and other courts proceedings in the future. But again, borrowing Richard's recommendations, I think it is important that we also have a strong and heavy justice focus on their reparations and remedy to the communities, especially the women's and their children's, and for their livelihood, not only for the reparations for the mental harms, in relation to the healthcare, access to like psychological or mental health, but also enabling other forms of reparations, such as livelihood buildings and long-term trauma care. I think the Survivor Fund was rightly discussing about it. So I think long-term strategic support for the survivors is very crucial. And right now, there is no, I do not know, or I'm not aware of any systematic approach to the reparations of the survivors of reproductive violence in Iran. I don't know if Survivors Fund or UN Women have that, but there is no NGOs that specifically focus on the long-term solution or addressing of these violence. Sorry, I took longer than I was supposed to be. I'm so sorry, but yeah.
No, thank you. It's very important points that you had to share and to add to what you shared earlier. So thank you, YY. I'll 2 minutes on.
Sure. And maybe actually I'll take a step back and say what I really want to emphasize is that addressing reproductive violence is essential for lasting peace. And it's something that cannot be overlooked. And yet there is a very concerning trend recently, especially in the context of Gaza, where we see the Board of Peace being established, where these issues are completely being disregarded. And I will say PHR documented and put out a report last year on reproductive violence in Tigray in Ethiopia, a different context. But what we found in that report was sexual violence being conducted as revenge for other violations that had occurred many years ago, to the point of finding literally letters in women's uteruses, during physical examinations, saying that that's what the sexual violence is occurring. It's to prevent you from giving birth, and it's revenge for acts that had occurred that similarly had targeted other women. And so it's, and then we're seeing again violence occurring in other parts of Ethiopia that are again playing into these same dynamics. And so we know that without addressing reproductive violence, we do not find sustainable peace. We actually find that these are the forms of violence that rupture social ties in communities and inspire revenge. And so, glossing over restoring access to healthcare, ensuring access to restoring reproductive autonomy, engaging women-led organizations and survivors themselves, it is not only a violation of rights and law, but actually really detrimental to peace as a whole. And I think that's the message I think we really need to close on.
Which is fantastic, because now you've said what I wanted was, thinking to say, which is, really linking this topic to sustainable peace and the impacts that impunity has for this type of crime, which really goes to the heart of communities, societies, and has these really lifelong, intergenerational impacts that we've heard about over the course of today. So I will just close by thanking our co-sponsors, Slovenia, the UK, Australia, Global Justice Center, Physicians for Human Rights, Global Survivors Fund, and the Women in International Law Interest Group of ASIL, and invite you to please join us in the foyer here to please eat some of our carbs and drink our coffee and enjoy some food with us and continue the conversation outside. Thank you all for your attention, and welcome to CSW.